Welcome. My today topic is offshore accident liars in Houston, Texas. Hiring the right offshore accident liar is important if your family member has been hurt while working as a dock worker, seaman, or oil and gas industry employee. These jobs are very difficult and dangerous. You rely on your employer and other responsible parties to put in safety measures and make sure they are followed. Unfortunately, too many companies do not protect their workers. The attorneys at the Wealthman Legal Group will uncover any negligence that contributed to your injuries. We will fight to make sure you receive the money you need to pay your bills and move forward with your life. Call our Houston office at 346 646 5973 for a free consultation. What damages can I get for my maritime worker injuries? The answer is, as you offshore injury lawyer, our goals is to make sure that whoever is responsible is held accountable. We will make sure you receive the money you need to recover from your injuries and pay your bills. Damages you may be entitled to fall into two main categories: economic and non-economic. Economic damages are pretty straightforward. They may include money for medical expenses, hospital bills, medical bills, devices and mobility aids, medication, compass, therapy and rehabilitation costs, money for expected future medical expenses, weight lost due to your recovery, vocational rehabilitation, loss of earning capacity if your injuries will impact your ability to work over the long term or permanently. Not all losses are clear-cut or obvious, of course. No economic damages are meant to compensate you for emotional pain and suffering, electricity, and lower quality of life. In some cases of extreme negligence, you may have to the right to punitive damages. These are designed to punish the plaintiff. If you qualify as a seaman under the Jones Act, see below, you may be eligible for benefits called maintenance and cure. Maintenance compensates the worker for the cost of room and board as they recover. Cure is the cost of the injured seaman's medical expenses along with the transportation requirement to get to treatments. Once the seaman reaches maximum medical improvement, maintenance and cure benefits and maximum medical improvement means the person is as healthy as they are going to get even if not fully cured. What is the Jones Act and does it apply to my case? The Jones Act is also called the Merchant Marine Act of 1920. It is a federal law that gives seamen certain protections. It allows them to sue their employer if they are injured on the job due to employer's negligence. If you spend most of your time working on a boat or vessel in navigation, you may be considered a seaman. If you work on a vessel as a sailor, deckhand, diver, engineer, driller, mechanic, captain, mate, steward, cook, fisherman, or in another capacity, you may meet the definition of seaman. If you do fit the definition of seaman under the law, you are not eligible for workers' compensation. You must seek compensation for your injuries through the Jones Act. Under the Jones Act, employers of seamen are required to provide a reasonably safe work environment and maintain the vessel in reasonably safe condition. The Jones Act holds employers liable even if the injured worker contributed to the accident in some way. Examples of unsafe conditions that employers may be liable for include broken or poorly maintained equipment, oil or grease on the deck, lack of proper training, lack of proper equipment, negligence of a co-worker assumed by a co-worker, failure to provide sufficient manpower, and failure to provide warnings about hazards known to the employer. Generally, you must file your Jones Act suit within 3 years of the date of the accident. Please note, always speak directly with an attorney to understand the statute of limitations and any other deadlines that apply to your claims. If you do not qualify as a seaman according to the Jones Act, there are other laws in place that may apply to your case. These include the Outer Continental Shelf Lands Act and Longshore and Harbor Workers' Compensation Act. If your loved one was killed in a maritime accident, the Death on the High Seas Act may apply. Serious head injury, severe back injury, burns, loss of limb, maritime worker injuries are often terrible, life-changing and expensive. If you are a loved one has been hurt on the job, you need a lawyer to guide you through the complicated laws. An attorney will help you determine the right channels through which to seek compensation for your losses. Do not go about this alone. How much is my offshore accident case worth? It's impossible for us to determine exactly how much your case is worth and without meeting with you and researching your case. Even then, past recoveries cannot predict or guarantee future outcomes. There are many variables that help determine how much money you may receive. Your pre-injury salary, your medical bills and other expenses, your estimated future medical expenses, whether and when you will be able to return to work, your non-economic losses. Whether you will pursue compensation through the Jones Act or workers' compensation, the attorney at the Welshman Legal Group look forward to discussing your case with you in detail. Initially, consultations are free and we do not get paid unless you do. Call our Houston office at 346-646-5973. Why do I need an offshore injury lawyer? If you have suffered an offshore injury, a representative from your employer or their insurance company may approach you with an offer of money in this stressful time. You may be struggling to recover and worrying about medical and household bills. It can be tempting to accept this initial payment, but while it may help out in the short term, you are throwing away the right to pursue further action. You will probably not receive the full amount you should for your injuries. Only an offshore accident lawyer understands the laws in these types of cases. The attorneys at the Welshman Legal Group have the knowledge necessary to identify all responsible parties and figure out the full scope of your losses. Determining which laws provide protection to injured offshore platform employees can sometimes be difficult. The location and type of the platform, whether permanent or movable, determines what law or laws may affect a claim. Because of the dangerous work conditions and the heavy and awkward size of equipment and gear involved with working on offshore platforms, injuries are very common, but determining reliability can be complicated. The injuries may be due to negligence of an employer, a contractor, employees of the contractors, or even the manufacturers of equipment involved in the injury. Offshore workers do not know what steps they need to follow to protect their rights. At times like these, we understand that putting food on the table remains top priority. But without a lawyer, injured offshore workers run the risk of shortchanging themselves and their families. How our team help injured offshore workers. At the Welshman Legal Group, we have dedicated ourselves to fighting for hurt offshore workers and their families. We provide comfort and good advice during the difficult time. There are specific time requirements that must be met when filing these types of claims. Therefore, you must speak with an offshore accident lawyer for our office as soon as possible after the accident. Call us now to schedule a free appointment. What should I do and not do after my offshore accident? When you have suffered a bad workplace injury, you may be in pain, worried about bills and your future, and just not thinking clearly. But what you do and do not do in the immediate aftermath of your accident is important. I can have a very real impact on your ability to claim compensation for your injuries. First, do seek medical attention no matter where you are or how serious you think your injury is. It is important that you get medical attention right after your accident. For one thing, your health and wellness should be your number one priority. Medical professionals can test for issues that may not be immediately noticeable. Also, you must have a solid paper trail of your medical problems and expenses when we file a claim. So either call your personal doctor or get to emergency room as soon as possible. Do inform your employer about your injury immediately. It is important that they know about the accident right away. This enables them to fix and safety issues and protect other workers, and it's an important part of documenting your claim. Do not assume that co-workers will report your injuries for you. If at all possible, do it yourself. Even better, write a full report of the accident and your injuries on paper. Give one copy to your employer and keep one for yourself. Third, do your best to document the accident. Take note of any witness, collect their contact information, take photos of the area where the accident happened and any relevant equipment and safety problems. Speak to an attorney. A lawyer experienced in these types of cases can advise you on steps to take and mistakes to avoid. They will help you understand the complex law or laws that may apply to your claim. Do not discuss your case with anyone except your lawyer. You must report your injuries to your employer, of course, but discussing your injuries with coworkers or others can backfire big time. Even the most offhand comment can be held against you in a court of law should you show your employer at a later date. Do not sign anything given to you by your employer. Do not accept money from them or their insurance company. By doing so, you may sign your rights away or accept a low settlement after that is far less than what you deserve to receive. Always speak with a lawyer first. My loved one was killed in an offshore accident. Can you help? Sadly, offshore workers all too often pay the ultimate prices their life while working in these challenging and dangerous conditions. Their families are left in shock, emotionally devastated, and financial ruin if their loved one's death is determined to be the last of negligence. Spouses, parents, and children of the worker may file for compensation under the Jones Act. They may receive money of losses including. Thank you so much.